There we go. All right, we're here. Muting again. It's perfect. We get to do the intro again. It wasn't a great intro as it was. We are here to talk Mark Bederow. Will he be allowed to join Karen Reed's defense team pro hoc vice? We've got the supplemental information that Yannetti added to that motion, and we have Judge Cannone's order. So we already know the answer, but let's talk about why and whether or not she's right. We're going to read through everything David Yannetti had to say. Did he solve all the issues that could have possibly come for Judge Cannone, or was she right in denying this motion? All right, so I was literally in the middle of streaming or of recording a video talking about the motion, the supplemental information added by Yannetti. And then the order dropped, and this was one I wasn't really sure of. I could kind of see arguments on both sides, but we're going to get to why the judge ultimately denied this motion, whether or not we agree with it, whether or not it's just another, horrible decision, or if we think there's some bias here, if we think this is something that, is really going to show us some major appellate issue that's going to be totally unfair. We're going to talk about all of that. All I'm thinking about, because I'm stuttering here, is my muted mic in the beginning, but we're here. We're going to read Yannetti's motion first, then we're going to read the judge's orders, then we're going to read the rule of professional responsibility dealing with conflicts of interest from lawyers that was cited by Yannetti and cited by Judge Cannone to determine what happened here. Was it right, or is this some extreme bias showing off here from the judge and not allowing this criminal defendant to get the lawyers that she wants and that want to work for her? So lots of questions. It's important. Stick with me. And here's what else I'll say. I'm glad we were able to do this live and the timing just kind of worked out. And I'm going to answer questions. And I want to answer questions. And people that disagree, there's going to be people that disagree with what I have to say in this video. There are people that disagree with what I had to say in the last video. The only real point of this discussion is, if we can disagree respectfully, ask questions, give me your comments, tell me why you feel a certain way. I'll read them. I'll respond to as many as I can during the video. We'll learn from each other. We'll continue to grow, continue to get better. Being a douche or condescending or jerk or making personal attacks at me or anybody else, it's just not worth the time. So you can do it if you want. Not going to read it. Not going to be interested in it. Not going to affect anything I say in the future, which is probably what annoys people the most. But none of that really affects anything I say. You know what can affect what I say? A respectful and well thought out comment, whether it agrees with what I say or doesn't agree with what I have to say. So enough of that. Let's get into it. Let me pull this up. I think it's a little too big. Gotta make it a little smaller. There we go. All right. Supplemental motion for admission pro hoc vice for Mark Bederow. David Yannetti of the Yannetti Criminal Defense Law Firm and a member in good standing in Massachusetts hereby moves to admit pro hoc vice Mark Bederow so that he may associate in as counsel of record for the defendant in the above captioned matter on the following grounds. At the court's directive, this affirmation is intended to supplement my pending motion for admission pro hoc vice for Mark Bederow. Bederow may represent Karen Reed at her upcoming trial before this court. I incorporate by reference the motion I already filed. The source of the information contained herein describing Bederow's qualifications and background comes from my conversations with him and information he's given me. If the court requires any additional information not contained in this affirmation, Bederow is available to speak to the court ex parte about any issues relevant to the motion. So that's an important line there to me. And that to me says, if you think there's something majorly wrong with this, or something we need to iron out, something we need to get more details about and get something on the record, let's have an ex parte hearing. You can talk to Bederow by yourself back there and figure out if there really is a major issue here. So that sentence is important to me, especially in light of what we now know. Mr. Bederow has been a member in good standing of the New York State Bar since '99. He's also admitted to practice in the state of New Jersey, the Southern District of New York, and the Eastern District of New York. He is presently admitted pro hoc vice in Massachusetts on 3 criminal matters, 2 of which are pending in Norfolk. The other is pending in Dedham. Mr. Bederow, in 2009 and 10, Bederow was admitted pro hoc vice in the District of Connecticut in connection with a complex federal criminal matter in more than 26 years of practice. Bederow has never been sanctioned or disciplined by any court in any jurisdiction in which he has been admitted to practice. So when we talk about experts and where the bar is for a judge to determine an expert, the bar in determining whether somebody's qualified to be pro hoc vice is way lower. Basically, are you a member in good standing? Is somebody a member in good standing in our state? We're willing to sign off on you and recommend that you should be able to do this. Bada bing, bada bang. And you're basically in. Bederow is plenty experienced, great lawyer, never been sanctioned before, which is why it's such a big deal when we talk about Spyro and Busby and even Alan Jackson in this case, Once you get sanctioned, once you have those issues, they can become a black mark on your record that you have to deal with every time something like this pops up. So it's a big deal. None of those issues, there's no way on qualifications or ethics that she is going to not allow Bederow to come on the defense team. But that's not the major issue here. Good cause exists to grant this motion because Mr. Bederow has specialized skill and knowledge in representing criminal defendants in matters of this nature. Since 98, he's been engaged in the practice of criminal law. 98 2004, he was an assistant district attorney. From 2004 to 2008, he practices in a large national criminal law firm. Since 2008, he's had his own firm in Manhattan. He's been involved in complex homicide cases and other serious cases, including some with issues similar to those in Miss Reed's case. And Ms. Reed values Mr. Bederow's experience and legal skills and desires that he be allowed to represent her at trial in this matter. So we know the background. We know Karen Reed wants Bederow. We know Bederow wants to work for Karen Reed. He's qualified. He hasn't been sanctioned. No ethical issues. He's actually already been admitted pro hoc vice in Massachusetts. Like we said with the experts, the bar is much lower for pro hoc. And if other jurisdictions like Connecticut and Massachusetts are allowing you to pro hoc in, it's almost a rubber stamp. Unless there's something more, right? Unless there's something more. So when we come to his qualifications, that's never going to be a reason to let somebody or to not let somebody like Bederow come in and practice law in this state. But we're getting to the big issue now. And Deja Vu said, my mind can't handle that hat. It's inverted. It's a totally true and accurate representation of what my hat says. Thank you, Lisa. All right, let's get to the major issue here. As the court is aware, Mr. Bederow presently represents Aidan Kearney on 3 criminal cases in Massachusetts. So those are the 3 cases mentioned before that he's been admitted pro hoc into Mass. One of those cases involves several witnesses who are scheduled to testify against Ms. Reed. Prior to the filing of the instant motion, Mr. Bederow conducted separate and extensive discussions with both Ms. Reed and Mr. Kearney. He defined and explained actual and possible conflicts of interest and the concept of waivable conflicts. So let's stop here for a second. So when you have either a conflict of interest already or a potential conflict of interest, co-defendants, co-plaintiffs, so many different ways you can have potential conflicts of interest, but people sometimes want to use the same lawyer. Sometimes that's absolutely the right decision. There are times that we do it in, injury cases or wrongful death cases when multiple people die in a plane crash or get injured in a truck accident or whatever it may be. There are different considerations depending on everybody's actions. If you have clients that are suing each other, you can't do it, not waivable. If you have interests that are adverse to each other, obviously unwaivable, can't do it. But then there are some issues that become waivable conflicts and others that are gray areas, right? And if a lawyer, and I don't know all the details of Aidan Kearney's case, and neither do you, right? A lot of you guys have read up on it and are way more well-read on it and know way more than I do about those cases. Absolutely. And that's not what I mean to say you don't know everything about it. What I mean is, unless you're the lawyer and the client in the case, I don't care how public it is, there are going to be things we don't know. There are things we don't know about the Karen Reed case, things we don't know about the Aidan Kearney case. But these people involved know. And he had individual conversations with Kearney and with Reed, explained to them what's going on. They all felt like it was fine to have a waivable conflict. We know from Charlie Adelson that you also need to make sure it's in writing and signed. And because you're a lawyer and you're explaining to them legal issues that they're going to have to waive and determine, it's also best practice for you to say, go ask some other lawyers. If you have your own lawyer or you can call a lawyer, ask them if they think this is a good idea. He checks all those boxes in this situation. So let's take a read. He defined and explained, okay, actual and possible conflict. He explained to Ms. Reed and Mr. Kearney the possible conflicts that could arise in his representation of both in separate matters that involved some of the same witnesses. He answered any questions either client had. He reviewed rules 1.7 and 1.8 of the Mass Rule of Professional Conduct. We're going to read 1.7 together with Ms. Reed and Mr. Kearney, and then presented both with copies of those rules. I mean, above and beyond, which is what I would expect from Mark Bederow. Mr. Bederow instructed both clients to speak separately with their other existing counsel about these issues. Both clients discussed these issues with their own counsel outside of Mr. Bederow's presence. After both clients expressed an interest in his representation after they consulted with their own counsel, Mr. Bederow prepared a detailed written explanation of possible conflicts of interest and what could happen in the event of an actual conflict of interest. And it doesn't say here, but most of the time an actual conflict pops up. If it's waivable and they've waived it, then you're fine and you can keep representing them. If it's unwaivable, usually the answer is you've got to conflict off both. You've got to be out on both cases. You can't represent Kearney and you can't represent Reed anymore, and that's a risk that clients take. Now, most clients don't have 2, 3, 4, 5 lawyers like Reed does, and I think Kearney's got at least 2 lawyers. So that's a bigger deal, right? If we're handling a case, usually we're the only firm on it. So if we conflict off, it's like now you both got to go find other lawyers. So it's a big deal, but you have to explain that to a lawyer. If it pops up, it's an unwaivable conflict. The judge finds that I have to get off your case, Miss Smith. Well, Mr. Johnson, I got to get off your case too. And it's not like you can say, oh, Miss Smith has the bigger, better case, like Miss Reed, a higher profile case. I'm going to stick on that and drop you, Kearney. Or I had Kearney first and then join Reed. I'm going to stick with Kearney. Usually you're conflicted off both cases. So that's usually what happens. Both clients, if there is a conflict later, both clients, with the advice of their own counsel, acknowledged they understood these issues, confirmed that they wanted Mr. Bederow to represent them, and executed written waivers to any possible conflicts of interest related to Mr. Bederow's representation of Miss Reed and Mr. Kearney. Both Mr. Bederow and I can unequivocally confirm that okay, now paragraph 8 is kind of the big issue. So right now it sounds all good. No issues. They're going to waive any conflicts. Paragraph 8. Both Mr. Bederow and I can unequivocally confirm that there is and never has been a joint defense privilege between Ms. Reed and Mr. Kearney. There's been accusations of things like that, but they're saying it's never happened. Mr. Bederow has not shared any protected material provided to him as part of his representation of Mr. Kearney with Ms. Reed, her counsel, or anyone else. So here's the issue. Here's the first issue for the defense, okay? So he's saying, and we know there's protective orders. We know there's things in Reed's case that they're getting that Kearney can't have. There are things that Kearney's getting, it sounds like, that Reed can't have, or at least there might be. And Yannetti in this motion put that none of that has been shared. Mr. Bederow has not shared any protected material provided to him as part of his representation of Mr. Kearney with Ms. Reed. So you know you can't share it with Ms. Reed. But he also said, or her counsel. So this sounds like an admission that you shouldn't be sharing this type of information with the counsel of Ms. Reed, which he's absolutely 100% right to say. But if Mr. Bederow becomes counsel for Ms. Reed, now he has that information that you're not supposed to share with counsel for Ms. Reed. Now, there are arguably ways around this, but that is our first potential issue as we see as a potential out if Judge Cannone does not want to allow Mr. Bederow on this case. Mr. Bederow has never engaged in any conduct during this representation of Mr. Kearney or anyone else for that matter for the purpose of harassing or intimidating witnesses against Ms. Reed and or Mr. Kearney. Mr. Bederow will not share. Here's the other thing. Mr. Bederow will not share any protected material provided to him on Ms. Reed's case with Mr. Kearney or vice versa. So this is basically a lawyer swearing to do the right thing. And there have been in this cases, nobody trusts each other in this case very clearly. And both sides are pointing the finger at each other, saying, you did this wrong, you did that wrong. And there are all sorts of times in all sorts of cases and all sorts of trials where you have to take people at their word. I swear to tell the truth, and the witness gets on the stand and tells the truth. They say they're telling the truth. Now, the jury can judge their credibility, but we're taking people's word for it. Same with the lawyers. When they put something on the record, they say they did it in good faith. You take their word for it. Now, if it's provably false, that's an issue. But, and I see people saying, can't they build a wall? I think that's a good point. I think they potentially could, and I think you can spell out specific ways how in an ex parte meeting with the judge, between the judge and Bederow. But at this point, he's basically saying Bederow's going to turn his brain on for the Karen Reed case and then off with Reed when he goes to Kearney, and then turn the Reed side or the Kearney side on and the Reed side off. I think potentially it could be done, and we could put protections, and we trust lawyers to be ethical. I know you guys might laugh at that, but I truly do. People are saying it's pronounced Carney. I apologize. I don't think that Turtle Boy would take offense to that. I think he's got thick skin, and I've probably said things he likes less than accidentally mispronouncing his last name. So I apologize for that. Okay. Mr. Bederow had no role, and this is another thing, right? Because accusations have already been slung by Mr. Brennan. Mr. Bederow has had no role in the preparation of a recent motion filed with this court, which led to the Commonwealth to seek sanctions over an alleged violation of protective order due to the inclusion of a text message sent by Michael Proctor. First off, the fact that the text message was there was not the issue. It's that it was unredacted. It was not something shared between parties, right? It was just the way it was presented in the motion as unredacted. Mr. Bederow was not provided any protected material by Ms. Reed, her counsel, or anyone else in connection with that motion. Shortly after that motion was filed, Mr. Kearney's attorneys filed a motion to dismiss the indictments against him. That motion included references to some text messages and electronic communications that were subject to a protective order in that case. The publicly filed version of that motion, which is available for this court's review, includes redactions of any messages that are subject to the protective order in Mr. Kearney's case. In one footnote, there is reference to a series of many inappropriate statements made by Michael Proctor, all of which were in the public record before Mr. Kearney's motion was filed. On February 18, 2025, the Commonwealth stated that it did not object to Bederow's admission pro hoc vice or the defense providing additional information to this court ex parte before the court decided this motion. So that last paragraph is important. I want to talk about it in a second. But all the stuff between Reed and Bederow, we know that Brennan is requesting more telephonic communication, more information, and we don't know what they're going to find, what they have found, what's been turned over to the judge. At least I don't know. We know that Hank Brennan made comments without a signed affidavit under oath, without any notice to the defense. I don't believe he filed an opposition with the information in it to this pro hoc vice motion for Bederow. I could be wrong about that. I could have missed it. But Ashley, basically my research assistant in this case, who sends me all of these documents, including this one, told me, or I mean, it has not sent that to me, so I haven't seen it if it does exist, which is amazing, by the way, because I'm on vacation here doing a million things. We toured this college today. It was amazing. It's so nostalgic. Love being here. But if I'm working, then it's hard for me to also do all the research and pull all these things. I do it, but it's awesome when you guys send it to me. So thank you so much. When I say I can't do this without you guys, I literally couldn't. So I haven't seen it if they did file an opposition with an affidavit signed under oath, but he sure as heck made the arguments in court. But what's annoying is just like what Hank Brennan did in the ARCA situation, Brennan said, we don't have an objection to Mark Bederow being added pro hoc vice. We don't have an objection to that. But judge, you should consider the conflict of interest issue between Carney and Reed. So while he said that he doesn't object, he actually does object. It's like, I don't really care, judge, but I do. And that's important when we read the judge's orders. First off, he also was perfectly fine if the judge would have had an ex parte meeting with Bederow to dig in. I don't think that has happened. I assume we can ask Mr. Bederow, but I don't think that has happened. And yet the judge's order is here. It's a little smaller now. Sleuthy sent me this. That's where I got it first. So thank you for that. Decision and order on defendant's supplemental motion for admission pro hoc vice of Mark Bederow. After review of the pleadings, the defendant's supplemental motion for admission pro hoc vice of attorney Mark Bederow is denied. The affirmation submitted in support of the motion is insufficient on its face. In addition, the proposed concurrent representation involves a conflict of interest that is not waivable under Massachusetts Rule of Professional Responsibility. See Mass Rule of Professional Responsibility 1.7, A and B, and see also comments 22 and 23. We will read those together. So what the judge is saying here is if this was a waivable conflict, I believe, as a lawyer who has done this and put conflict waivers together before in criminal cases and in civil cases and have had judges with no problem with it. If it was a waivable conflict, I believe Mark Bederow did every single thing perfectly that you should do if you have a situation like this, which could be a potential conflict. Okay? But the judge is determining this to be an unwaivable conflict. And if you remember in Adelson, I think the same thing happened. He said, first off, there was no conflict in writing, but also this is an unwaivable conflict if Charlie Adelson's going to come and be an adverse witness to Donna Adelson potentially at trial called by the prosecutor. Here's what I'm going to say that a lot of people that are behind Karen Reed and behind the injustice, and just so you know, okay, just so everybody knows, every individual thing that I say, every decision I make, every thought I have, every opinion I have on a legal matter is not always the ultimate issue in the case, right? Just because I think Judge Cannone was completely biased in the way that she dealt with the two dog bite experts, and I think that it showed through and it was not the way it's supposed to be done, doesn't mean I am going to consider every decision she makes on the case, just like I haven't, to be a biased decision. People might not like that, and I understand that, But I have to look at it and say, okay, I understand this call that's made by a judge. I understand this argument that's made by a lawyer, or I completely don't. And it also doesn't mean that I think Karen Read is guilty or not guilty, right? Each individual decision I make on a legal filing, on a hearing, on anything like that is not always the ultimate issue in the case. So I hope everybody can understand that. And I hope we can still have conversations and disagreements. And if you disagree with what I'm about to say about this, let me know and let's talk about it. Does it suck for Karen Read's defense team? Yes. I think Bederow would have been great. Do I think that there are situations where you can take a lawyer at his word, build a wall to where we can set up a way that no information that should not cross paths could? I think that is possible. But I also think that there is a legal reason and there is a basis in law for Judge Cannone to deny this motion for pro hoc vice. I don't know all of the information about, the protective order, what's going back and forth, what one side has and doesn't. I don't know if it's one document. I don't know if it's 100 documents. I do think that would make a difference. If there was one document, then I really don't think this is right. But if there's multiple documents that may still continue to come out, then I think that this decision might make sense. And the judge, whatever you think about them, is the gatekeeper and sometimes is actually legally allowed to protect a client from themselves. We saw it with Donna Adelson. Donna Adelson still wanted Rashbaum to be her lawyer. Charlie wouldn't waive the conflict now. So too bad. So you picking your lawyer is not an absolute right. It should be pretty close to that, but it's not necessarily an absolute right. And I understand this if you think Judge Cannone is biased, this was an out that she was given that she took. If you think that she's a great judge, this is a decision I can understand the legal basis of. And you guys are asking great questions, and I see a bunch are in here. I think I'm going to finish going through the document first, and then I'm going to answer a slew of questions. So you guys can get your question. I'm almost done with the document, so we'll have time for questions. And by the way, Kelsey, go ahead and star some good ones if you see them coming through. All right, let me finish the reading here. One such conflict, and by the way, she says one such, so not the only conflict, which I thought was interesting, is specifically outlined in the motion at paragraph number 8. I highlighted paragraph number 8 for you, where Bederow, apparently speaking through Yannetti, promises to restrict his use of certain information. The clear inference of the promise is that Mr. Bederow would not use protected information gained in the representation of one client for purposes of his representation in another client. You're not allowed to do that. So adverse, obviously you can't do. You also can't go get information that you shouldn't be allowed to have. So if you represent Aiden Carney, you can't get certain information. If you represent Karen Read, you can't get certain information. That's only relevant to Carney's case or only relevant to Read's case. So if he's going to have both, the judge sees that as an unwaivable conflict. Now, there are situations, in my opinion, that you could take I've already said this, so I don't need to repeat myself, but sometimes I feel like I've always got to give the it depends or, extra qualification on it, but we'll keep going. The clear inference of the promise is that Mr. Bederow would not use protected information gained in the representation of one client for purposes of his representation of the other client. He thus proposes to ignore information known to him through his representation of one client, even where the information might benefit his second client. The court cannot permit such conflicted representation and declines to add to the defense team that currently numbers at least 4 lawyers, 3 by admission pro hoc vice. Is that a little wink that she's not going to kick Alan Jackson off the case? To deny Bederow and kick Alan Jackson off, by itself, I don't think this is a huge appellate issue. If she denies Bederow, kicks Alan Jackson off, I think it becomes even more of an issue potentially. Not the best appellate issue they have because they've got plenty. Defendant supplemental motion for admission pro hoc vice of Mark Bederow is hereby denied. It sounds like she was just like waiting for Yannetti to finally turn in that information so she could deny it. So she has denied it. Let's look at these rules of ethics here. There's something else I was going to say, but I can't remember. So let's pull up the ethical rules here in Mass. All right, this is rule 1.7 that they cited, paragraphs A and B, and then comments, I think it's 22 and 23. Except as provided in paragraph B, a lawyer shall not represent a client if representation involves a concurrent conflict of interest. A concurrent conflict of interest is an interest exists if the representation of one client will be directly adverse to another client. We don't have that here. If anything, they seem like they're united at this point. but relationships can fall apart, right? And then some conflict between the two of them could pop up, and then he'd have to be off. There is a significant risk where the representation of one or more of the clients will be materially limited by the lawyer's responsibility to another client, a former client, a third person, or a personal interest of the lawyer. It's possible that she finds in that paragraph some issue with the information with the protected documents. She didn't cite the language specifically. So, notwithstanding the existence of a concurrent conflict of interest under paragraph a lawyer may represent a client if the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. I think he would, and they would. The representation is not prohibited by law. The representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal. So that would be like if, they're aligned here, but Karen Reed was suing Aiden Carney for something totally unrelated, that would be a problem. Each affected client gives informed consent confirmed in writing. So, was it informed consent? Does Judge Cannone think they don't fully understand the issues going on here? Well, it looks like informed consent in writing. Let's go to comments 22 and 23 here. I can't wait to read your questions, honestly. Consent to future conflict. Whether a lawyer may properly request a client to waive conflicts that might arise in the future is subject to the test of paragraph B. The effectiveness of such waivers is generally determined by the extent to which the client reasonably understands the material risks that the waiver entails. So does Judge Cannone look at this and say they don't understand how this protective order works and how a lawyer can't, turn off part of what he knows from one side to the other? The more comprehensive the explanation of the types of future representations that might arise and the actual and reasonable foreseeable adverse consequences of those representations, the greater the likelihood that the client will have the requisite understanding. It sounds like from Yannetti's motion that Bederow did everything he possibly could to discuss this, to give them the rules in writing, to give them the conflict waiver in writing and have them talk to other lawyers. Sounds like he did everything he possibly could do. Thus, if the client agrees to consent to a particular type of conflict with which the client is already familiar, then the consent ordinarily will be effective with regard to the type of conflict. If the consent is general and open-ended, then the consent ordinarily will be ineffective because it is not reasonably likely that the client will have understood the material risks involved. Again, I don't know what conversations were had. I don't know how specific they got. It could be general. It could be specific. Seems like Judge Cannone thinks it was too general, potentially. If the consent is general, I already read that. On the other hand, if the client is an experienced user of legal services, would you consider them at this point? I kind of feel like they are experienced users of legal services involved and is reasonably informed regarding the risk of a conflict that may arise. Such consent is more likely to be effective, particularly if the client is independently represented by other counsel in giving consent and the consent is limited to future conflicts unrelated to the subject of the representation. In any case, advance consent cannot be effective if the circumstances that materialize in the future are such that would make the conflict non-consentable under paragraph B. So, first, future conflicts unrelated to the subject of the representation. That's not the issue here. The conflicts Judge Cannone, is looking at, or future conflicts or potential conflicts are all regarding, they are related to the subject of the representation. So that's part of the issue. And if the judge is going to say, I'm going to protect you guys from yourselves, and I don't feel like this is something you can consent to, it's a non-waivable conflict, it's not something you can consent to or able to consent to, then legally speaking, she does have the power to do this. Conflicts in litigation. This is the other one she cited. Paragraph B3 prohibits representation of opposing parties in litigation, regardless of the client's consent. On the other hand, simultaneous representation of parties whose interests in litigation may conflict, such as co-plaintiffs or co-defendants, is governed by paragraph A2. So they're not technically co-defendants, but does she think that there will be crossover and they may conflict at some point? A conflict may exist by reason of substantial discrepancy in the party's testimony, incompatibility in positions in relation to an opposing party, or the fact that there are substantial different possibilities of settlement of claims or liabilities in question. Such conflict can arise in criminal cases as well as civil. The potential for conflict of interest in representing multiple defendants in a criminal case is so grave that ordinarily a lawyer should decline to represent more than one co-defendant. Even with all this language, by the way, it's absolutely allowed all the time and happens all the time. Maybe it's not the best thing, but it does happen. Or more than one person under the investigation by law enforcement authorities for the same transaction or series of transactions, including any grand jury proceeding. On the other hand, common representation of persons having similar interests in civil litigation is proper if the requirements of paragraph B are met. By the way, I should say that a lawyer representing multiple criminal defendants is probably not advisable, not what you should do, but it does happen. It does happen. It wouldn't be like this is the first time ever that we'd allow somebody with similarly situated defendants. They're not co-defendants. I get that. Okay. So here we go. I can't wait to get to these questions. I feel like the judge is in someone's pocket. I don't know. I don't know that answer. Mrs. Pakistan in the house. Thanks for the live about this. We are outraged. Okay, I am. Your hat is upside down and inverted like the Sallyport video. Happy Friday, everyone, and enjoy your weekend. It's a true and accurate representation of what my hat says. If Bederow was admitted to Massachusetts bar, could she deny him? Yes, she could and did deny him here. It's not a qualifications issue. It's not a, can this guy just if he wanted to go represent John Smith right now in Massachusetts, I can almost guarantee you it would be admitted. It is specifically about the conflict of interest between his two clients in Massachusetts that this judge finds that he would not be able to deal with getting protected information from each side. I don't know what that protected information is. I don't know if there's adverse things in the protected information. So we're in the dark a little bit here. And it's not something Bederow is going to be able to talk about. Bias Bev bans Bederow, but Brennan Blarneys. I see what you did there. Peter Piper picked a pack of pickled peppers. How many pickled peppers did Peter Piper pick? My B. Given the KR and AK connection, do you feel her team will ask her to take the plea deal? No, I don't. Can Bederow and KR's attorney still share info if both parties agree? So yes, but not if it is confidential or subject to a protective order or the judge says you can't share the information. Generally speaking, if it's public and it's accessible, they can discuss defense strategies together. Without waiving, they can't waive attorney-client privilege, obviously, but there are things you can still work together on, as long as, of course, there's not something in place that says you can't. Just feels to me like Bev is going to deny everything now that Jackson has beaten her in oral arguments twice, and he's now making records of her bias. I don't think she's just going to deny everything. I don't think that's what's going to happen, but I think, if you give her an out, she's probably going to take it. That is kind of what it feels like. Welcome to back, Mo and Mary. Let's see what else we got. Peter, doesn't Norfolk DA and Turtle Boy case share information with Norfolk DA and Karen Reed case? Well, that's a little different rules because they're the prosecutors, right? Now, theoretically, if things are subject to a protective order, the lawyers working on the specific cases shouldn't be sharing it back and forth. Definitely shouldn't be using it against the clients or in those cases. But I get what you're saying. Trust me. Bev decisions and actions are very concerning. Is there someone we can contact who can investigate our concerns? I don't really. I mean, they're subject to, sanctions by the Massachusetts bar. I think judges are appointed. So they're appointed by probably an elected official. I don't know who appoints. I don't know how it works exactly in Massachusetts. In Florida, they're voted on. So there's probably someone you can vote for or talk to that represents you, that you can probably write a letter to. Bill Foster, can you do a 10, 20-hour stream about all the appellate issues if Karen Reed is convicted? That's a good question, Bill. But additionally, there's so much Koberger stuff going on with the text messages and the comments, and I want to wrap my arms around it. It's just literally been impossible to try to synthesize it and put it all together. My guess is Sleuthy has something. Maybe she can send me something where it's like, here's what's going on. Here are the most pertinent documents. It's amazing the people that get involved and interested in these cases and how they put stuff together. Maybe I agree with them on some cases. Maybe I don't. Maybe they agree with me on some cases. Maybe they don't. But it's still a really cool, just like community in the true crime world. And I hope that people can stick around if they disagree on one case and agree on another. That's kind of what makes it cool. And that's what makes America, should make America, America. Can Bederow still work on Karen's case behind the scenes, but not be officially her attorney? It wouldn't be attorney-client privilege. I guess he could technically assist. It just kind of be dirty. I don't think that would be a good idea for him. So my guess is he wouldn't. So here we go. These are two good questions. Be kind, Tiger. What if judge in Turtle Boy case dismisses all the charges and then LP? What if Aiden lets Mark Bederow go as his attorney? So that would be an interesting question for Judge Cannone. I would refile this if that happened. If Turtle Boy fired him so that he could go with Karen Reed, or if the case is dismissed against Turtle Boy, then you say, Judge, conflict resolved. There's no future conflict. He has the information. He's not going to use it. Are you going to say you don't trust him to use it? Also, another thing that came up in my mind when I was reading this is the judge could also say, hey, listen, Brennan is pointing the finger at you guys for sharing information. You've pointed the finger at Brennan for lying. I don't want to have even the opportunity of that come up because, God forbid, something from the Turtle Boy case ends up in the Karen Reed case. Then we have a major issue. Then we have real sanctions happening for Bederow or somebody on the Karen Reed team. And Hank Brennan's going to make these accusations. Isn't it just cleaner and better to not have that appearance of impropriety? We don't have that issue going forward. If only it was that simple, because I have a feeling those accusations are still going to be made. She did this because Aiden's case will be dismissed soon. Well, I think they can refile this if his case gets dismissed, my opinion. Do you think the defense was just attempting this for another topic on appeal? I don't. I don't think that was the reason why. What would you tell your client at this stage of the case after these two denials back to back? Must feel extremely disheartening for Karen Reed. I think she gets exactly where she's at, and she understands this is going to be an uphill battle. I don't think everything Judge Cannone has done has been biased and unfair and horrible, but I think there have been some bad calls in this case. I really do. Kevin C. Peter, why does the judge have a right to decide who Karen picks to be her defense attorney? Because what you also don't want is for this case to go forward, for the prosecution to go convict Karen Reed, and then she's got this out to say, oh, Bederow should have never been my attorney. There was a conflict there. It was an unwaivable conflict. You, judge, allowed him to be my attorney. I'm going to win this appeal and do this trial all over again. The judge is the gatekeeper to protect the sanctity of this case and trial. Laugh at that all you want. Disagree with her all you want. But that is where her power comes from and where her discretion is. And in this scenario, that's one of the ways she can use it. It's because you have to realize these rules apply to all cases, not just the Karen Reed case. Can Bederow still help out behind the scenes? I'm guessing no. He shouldn't, in my opinion. If you ask me, I would say no. John Miller, what if judge throws out all the charges on Kearney? Could he be allowed then? A lot of the same good questions coming. I would try again. Because I think that issue's been solved. I would say I no longer represent Aiden Carney. Kelly, I knew this was coming when Hank mentioned Turtle Boy phone records yesterday. This is a 3-ring circus. Well, it's definitely a systematic approach, and it's not very different from the defense's approach sometimes, where you have something that you explain as an issue. Maybe the way you explain it and argue it makes it sound like a better issue than it may even be. Then you start to get information, or at least something that looks like information that's going to help you, and it snowballs into a big effect, whether or not it ends up coming to fruition. Now, the defense has just continued to uncover problem after problem after problem. So it starts out a lot of times just like the jury tampering, right? Seemed like it could be a problem. The defense got some information to be a problem. They got more information that maybe it wasn't as big of a problem. Some of you guys maybe still think it is. But then they've had other situations where they're like, we think this was a dog. And it's like, okay, what makes you think that just looking at a picture? Then they uncover a problem. More likely they get an expert to say it was a dog. And so it's like, not every issue is handled the same, but they're like, we think there's some protected information getting shared between the two. We want the phone records. Here's something that violates the protective order. Are they sharing this stuff together? Oh, this is concerted. They're filing this one motion, then the next motion. So is it something? I don't know, but I think that Brennan is working on making it look that way. Eric J. If Bederow and Turtle Boy agree to him withdrawing from Turtle Boy's case, could he then be admitted on Karen Reed's case without conflict, or if Turtle Boy's case is dismissed? It's not a guarantee locked and loaded that it would happen, but I do think it's possible. And I would refile this again if that were to happen. Marissa, would you only file a second motion of recusal if a confirmed conflict with the parties involved case, or is there another scenario concerned about fair trial? You're not really going to win just because you're losing motions. And we talked about this a lot in the YSL trial. And the judge tried to stay on. Glanville tried to stay on because he's like, they're just mad because they're losing, judge, and I'm disagreeing with them. And we're like, no, it's more than that. So you can't just say, we think she's biased because we keep losing things. It would have to be how she talks to them in court, which I don't think hers has risen to the level that Glanville was at. Not even close, my opinion. Again, you guys can disagree with that if you want. Chris K. Peter, no offense, but you are clearly biased towards the truth and justice. Seriously, though, I appreciate your honesty and integrity. That is why this channel is the best. Thank you. Thank you, Chris. You always send a nice message when I need it, so I appreciate it, Chris. Can Bederow work behind the scenes regarding Alessi in trial? I mean, they can consult with him, right? Because they can consult with me. They can consult with any lawyer that they're not consulting with me, by the way, just to clear that up. They can consult with any lawyer that they think might help. They're going to bounce some ideas off of. How would you argue this? But they cannot share any information that would be inappropriate. Commonwealth just asked for an extension. Defense provided info to the Commonwealth for 12 expert witnesses. Tagged you in the motion on X. Just never ending here. Never ending. Did everybody hit the like button here? I was planning on only going 20 minutes and we're already at 40. So what up, Mr. AC? Welcome to the crew. Paul Z. Hi, Peter. I don't know how you do this all day, every day. I have become so invested in this case, but I have zero confidence that Karen Reed will receive a fair trial with this judge presiding. Well, we're going to have an eye on it. All right. And we're going to talk about it and we're going to highlight it if there's problems. And I really think that that had an effect on the YSL trial. I really think if we do things respectfully and appropriately, they can have an effect. Might not always be our desired effect. It might not be as quick as we want it to be. But I think screaming at people, I think name calling, I think, just doing things that you really shouldn't do to your neighbor and your common man or woman, um, you can disagree respectfully. You can disagree in a way that does change people's minds and change people's actions, even if it feels impossible. Liza with a law dog. Off topic, but wanted to be sure you knew Lori Vallow is doing a Dateline interview tonight that looks a little unhinged. I heard about it. I didn't know if it was already out yet. It's just so much going on, so much going on. And I think people, I'm interested in you guys watching my breakdown of Morrissey's interview. BNB, really wish you would go over Turtle Boy's case. I got to be honest, like, I just feel like a ton is going on. I'm still in on Lori Vallow. I really got to get, my arms wrapped around the Koberger situation because I know a lot is popping off there. We have this case, Corey Richins. We got, so much going on right now. It's tough to be in on everything. Bobby, what would be the benefit of Bederow being added to Karen Reed's team? Do they even need him? That's a great question. I mean, the more great lawyers you can have, the better it is, right? The more great soldiers you can have, the better it is. Do they need him? The judge doesn't think so. Karen Reed does think so, right? I think that's a good enough, fair question. I don't think this means, all is lost. There's no way they're going to be able to handle this case. But I think they would have thought this would be nice and this would be really helpful. Welcome, Julie. I am confused and even sometimes irritated by Judge Cannone's rulings. However, this one makes sense. LOL. I can understand why she feels there may be a conflict. This is a very based. Is based a bad thing? I think based is like in logic. It's a solid take, Boston Breezy. Solid take. To be able to do this, even if you disagree with it, I like it. Dominic, how does a defense team decide whether to request a bench trial after hearing how the jury for Reed weighed in the evidence? Makes me wonder if a bench trial would be safer even with a biased judge. It's so funny. It's like, this judge is horribly biased, but maybe a bench trial would be better because you don't trust the jury. It's like not trusting anybody in the process is what this comment feels like, Dominic. It doesn't feel like, to me, like you think anybody can do the right thing in this process. And sometimes it's not a jury's fault if, what gets back to them has been chopped up in a way that's unfair. So I get what you're saying. I just highly, highly doubt that this would be a bench trial. And both sides would have to agree to it. Turtle Boy posted he's not giving up Bederow. And he shouldn't have to. I'm not, by no means that I mean he should or that he should have to. Because there's also no guarantee if he fires Bederow that the judge would even allow him to come on Karen Reed's team. Can the defense object to Hank when he makes these accusations in court? And why do you think they don't? They did. Jackson was pissed about it last trial. And he said, this is what they do, judge. And if the judge doesn't hold them accountable and force them to do it, I mean, all you can do is continue to protect the record. And again, do not take solace when somebody says, this is a great appellate issue. I know sometimes even I do it and say that, but when you have 1,000 appellate issues, that just creates an unfair process in an unfair trial, and you're never going to be able to appropriately explain all the appellate issues. Madam Secretary, hi, I sent you a DM on X regarding the double jeopardy and references to another Massachusetts case with similar charges. See also Brown v. Ohio. Love to hear your thoughts. Thank you. I will take a look at that. Welcome to Krista. I do have to leave here in like less than 5 minutes. So thank you, Mr. AC. There are 2 motions. Sent them to you on Instagram. In this case, you're talking about, Kim? I'll have to look. I will not be doing another video today, but we got the weekend. We got next week. We got time. We always have time. We'll hang out together basically every day. Laura, wow, I caught a live. I came in from the land of Ian Runkle, Edmonton, Canada, and I'm about to graduate law school. Congratulations. Your content has been incredibly insightful throughout my studies. Thank you. Thank you, Laura. I appreciate that so much. I really do appreciate that so much. I appreciate what all you guys have to say. Even the mean ones, I get it. Even the people that get really angry and really heated and, they think it's going to change the way I think or talk or handle my YouTube channel, and it's just not. Now, people have said, like, hey, can you try not to call her Judge Bev? I get everybody calls Judge Bev, so I try not to. Try to be respectful, right? I'm not sure. When I say I think it's a biased decision, it's a bad decision by a judge, it's not me being disrespectful. In case you haven't noticed, lawyers, 50% of the lawyers in the courtroom usually disagree with the judge's ruling, right? That's why we're there, to fight about it and let the judge make the decision. Kevin Hook, could Jackson ask to be off the case and put in a motion that he feels his presence is causing unfairness for his client? What would that look like on appeal? Of course he could ask off the case. I don't think he's going to. I don't think this is realistic at all. Comment, how come the clock on your wall behind you doesn't change the time? Because we're frozen in time, common sense. Just trust me. Just trust me. We're frozen in time. That's just how it works. LOL. Hope Martin, thank you. And that's it. I got to run. You guys are the best. You guys are literally the best. Don't forget to hit the like button. Share with anybody talking about this Karen Reed stuff. Make sure you're subscribed because I want to hang out with you guys again on this case. Make sure you hit the reminder bell so you don't miss any of the videos that come out. But that is all I've got. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.